Hi, and welcome to Chapter 10, the Judiciary, the third branch of government that we're going to be looking at today. And we're going to be examining the types of laws that we have in the United States. We're going to examine the nature of the courts and the federal court structure. We're going to be looking closely at the Supreme Court. Mainly the subject matter of the chapter is in Article 3 of the Constitution of the United States that deal with the judiciary or the judicial branch. There are 5 types of law in the United States. But what is a law? A law is the principles and regulations established by government that are applicable to the people and enforced by government. So there are principles and regulations and application of these laws that actually important that you look at that applicable to the people can carry out without burden to them and without constantly violating, and at the same time it could be enforced by government. Okay, so a law is a law only if it's applicable to the people and enforced by government, which is at the end is just principles and regulations that are established. So it regulates our expectations, it regulates the future, it regulates the present, it regulates how we look at the past, and so on and so forth. The first type of law that we're talking about is a common law. Second, statutory. Third, equity. Fourth, constitutional law. Fifth, administrative law. And let's look at them closely. The first is common law. This law based on tradition. Whatever in the past people used to make, we respect that tradition and we carry on with it. The common law arrived to the United States with the colonists, the settlers, the first settlers that landed on Plymouth Rock, 1620. And they brought the common law with them from Great Britain. So the basis of American common law came with the settlers and its roots in England. And common law, by definition of the book, is law established by post-judicial decisions. So whatever the cases were ruled in the past, you respect the precedent of these cases and you implement them in the future as well. And these are the laws that the English brought with them, the law system that the English brought to them in the colonies, and ever since became part of the United States, except for an exception of the state of Louisiana, out of the 50 states, because state of Louisiana used to be part of English, the French colony, and with the Louisiana purchase of Thomas Jefferson, this territory became part of the United States. But it's actually the Louisiana. The name of the state itself is the name of the King of France and the Queen of France combined together that gives us Louisiana as we know today. And this is the only part of the heritage of that state is tied more to France than that of Great Britain. Second is statutory law. Statutory law is a law passed by the Congress of the United States or the Congress of the state where you reside. So statutory law, we have 50 state statutory laws and we have 1 federal statutory law. And the statutory law is a law that is proposed by a member of Congress, debated in Congress, passed, signed by the President of the United States, and become a law. So most of the laws that we have that governs our areas of life is a statutory law. Okay, so when we're talking about regulation, for example, on air pollution, we're talking about regulation of water quality, we're talking about the legalization of cannabis. All of these laws are statutory laws. And the more statutory laws grew in size, the more they took place of the common law. Third type of law is equity. And equity is a system of laws that provides relief in situations in which the common law or statutory remedies are inadequate, especially through the issuance of injunctions to prevent injuries. So When we're talking about equity, you're talking about something that you want to stop because the injury may happen in the future. So most of the laws, the statutory law and common law, you cannot bring a case to court until the damage has already took place. Now, if you know that damage is going to happen in the future, what are you going to do? Which court are you going to go to? That's when you seek an injunction. You want to stop a law because the law is damaging. An injunction is a court order issued to forbid a person or a group from committing something they are trying to do, trying in the future, trying to do or about to do, restrain them from continuing to commit the act or require them to perform an act. And in that sense, if a factory opened down the stream of the river where I live, and the factory started to release pollution in the water that I'm drinking or using, just a metaphor, I don't have to wait until I get sick. Then I start suing the factory. I can seek an injunction in an equity type of law, in equity court, and ask them to stop building the factory or stop the operation of the factory before I get sick. So equity is developed to correct weaknesses in the common law. Fourth is constitutional law. These are the laws that are based on the Constitution of the United States. So your civil liberties, the basis of your civil rights, for example, all of these we're talking about things that are in the Constitution of the United States. And those provisions in the constitutions of the United States that interpreted by the judges, by the Supreme Court of the United States, become the basis of your constitutional liberties, constitutional rights, and so on and so forth. And finally is the administrative laws. These are the laws that are issued by administration. So, for example, IRS, for example, or let's say for the Department of Motor Vehicles. These are administrative laws. The rules and regulations issued by departments and agencies of the executive branch of government. So these are the laws like, for example, a traffic ticket, for example. Or, for example, administrative law is, for example, the laws that are passed by the IRS, the deadline that are passed by the IRS. If you don't pay your taxes on such a day and day, you have violated an administrative law. If you do not follow your taxes or you cheated, a person cheated in his or her taxes, that's a violation of administrative law. So let's go back again and quickly repeat them, what they are. Okay, we said we have 5 types of laws. The first one is a common law established by post-judicial decisions. This is law based on tradition in the past. The second type of law is statutory law. These are the laws that are passed by the Congress of the United States, if it's a federal statutory law, or the state legislators. Let's say, for example, in Albany, if Albany passes a law, this is a statutory law. Most of the laws are statutory laws. And then you have a law that actually is statutory and common law cannot deal with. For example, equity, a system of law that provides a relief in situation in which common law or statutory remedies are inadequate, especially through the issuance of injunctions to prevent injuries. Excuse me. And then we said constitutional law, it's law based on the provisions of the state and federal constitution. Finally, administrative law, the law that rules and regulations issued by departments and agencies of executive branch of government. Now, when we're talking about law, excuse me again, there are 2 types of law. There are laws that deals with criminal behavior, criminality, crimes, and there are laws that deals with civil laws. And there are differences between them. So civil laws, usually the penalties of them are fines. amount of money the person pays, while criminal law ends up in penalties of prison and in some situations life sentences as well. Criminal law defines acts that violate the public order and provides punishment for them, typically through a statute. And if you remember, who issues statutes is the Federal Congress of the United States, the Congress of the United States, or the Congress of the state where you reside, statutes. So all criminal laws, or most of criminal laws, are based on this provision of law. The government serves as a plaintiff in a case of criminal law, and the accused party is called a defendant. So the plaintiff is the one who brings the charges, and the accused is the one who defends the one who defends herself or himself from the charges that are brought by the plaintiff. State criminal law is derived from the reserved powers. Federal criminal law is derived from Congress enumerated power. So, if you remember the 10th Amendment, it says that powers that are not delegated to the national government, nor prohibited by it, are reserved for the states thereof. And therefore, this is the area where the states are sovereign, where they can pass laws in this area, statutes laws. States, in that sense, they have their power exclusively in this area. This is issues of policing, issue, for example, of safety, of morality, code of morality. All of these things are put under the reservation clause in the state criminal law, statute law. Enumerated powers of the Congress of the United States are stated in Article 1, Section 8. All of these powers that deal with the Congress of the United States, for example, the power to tax, the power to regulate the commerce, mainly regulating the commerce is very important. All of these powers are enumerated in Congress of the United States. And therefore, when Congress of the United States passes a statute or a law, it's based on this enumerated power at the federal government. When we're looking at the state, when Congress of the state of New York passes a law, it's based on the 10th Amendment reservation clause, which are reserved powers of to the states. And now we'll see the crimes are classified into two types: misdemeanors and felonies. A misdemeanor is usually a crime that is punishable by a fine or a short term in jail. So, for example, public urination, for example, consumption of alcohol in the street, for example, speeding tickets. All of these are misdemeanors in that sense. Now, there are some of them serious, some of them are less serious. But felonies are usually punishable by imprisonment of more than 1 year. That's a serious crime. For example, somebody who harmed somebody else, or theft, or so on and so forth. Federal criminal laws are enforced by United States Attorney General, that is appointed by the President of the United States and confirmed by the Senate. And there are Attorney Generals also at the state level. So this is the Attorney General is the person who defends the United States citizens against the citizen who committed that, who broke that broke the law, and charges are brought against them in court. Okay. So let's look at the degrees of seriousness now. Felonies, when are most serious, the punishment, all punishment options are available, including execution, prison, probation, or fines. Less serious felonies, what we call felony misdemeanor, could be punished as a felony or misdemeanor, and discretion is left to the prosecutor or the judge. It could be probation or something like that. Now, less serious misdemeanor, jail, probation, or fine. The least, which is what we talk administrative law, infractions or violations generally only fines, ticket, or something like this the person will receive. So this is the degrees of seriousness when it comes to criminal law. Civil law, on the other hand, law that defines the legal rights of citizens and thereby provides rules for resolving disputes between individuals and corporations, and in some cases, the government. So when we're talking about civil law, we're talking about disputes between two people. Family, for example, divorce case, property, couples are divorced and they are about to split the property, for example. Or, for example, there is an inheritance of a house and family members are fighting with one another of who should get the house. That's also part of contract. Somebody violated their contract or something like this, or trapped, for example. So civil law is found liable. The defendant has to compensate the plaintiff. In criminal law, if the person found guilty, the accused can be incarcerated and fined at the same time too. So in a civil court, we're talking about only money that is paid or amount of money, something that repairs the damage of that person. While in criminal law, found liable, and in criminal law, it's called found guilty. So example of civil law, again, is cases of divorce and negligence cases, for example. Now, the type of law that or the court system that we have in the United States is called adversary system. An adversary system is a judicial process characterized by the conflict of two or more opposing parties that appear before an impartial court and bring the evidence in front of jurors and examine the evidence, cross-examine the evidence in front of the partial jurors. So the idea that you have to bring both sides in front of court and they both sides question and examine the evidence that are brought in this case. And the idea is that the more that you have this two sides of the story, the more the truth is going to reveal itself. The underlying assumption is that the truth will emerge from the clash of opposing interests, defendant and a plaintiff. A plaintiff who brings the charges, bring the evidence, show them to the court, show them to the defendant's lawyers, and announce them what they are and announce the circumstances where they collected. The defendant stands up, the lawyer of the defendant stands up, start to question and re-examine and cross-examine this evidence that is brought against them. They bring witnesses, cross-examine the witnesses. All of this is happening in front of the jurors, and the judge is making sure that partiality that are taking place in the process of unfolding this adversary action between the plaintiff and the defendant, so that the jurors can have the best picture where they're going to make the final decision at the end. So adversary system. And the role of the courts. The plaintiff must have a legal standing in order to sue. In that sense, you cannot bring a hypothetical case to the court. The person must have a legal standing. The law must have been violated. The courts do not give advisory opinions on a legal issue. Cases must be brought to the court for their issue to receive the attention. No hypotheticals. And the judges have a role as well. So the role of the judges, a judge is a presiding officer of the court who makes sure the judicial process is followed. He's a referee in our system. The judge is the referee between the plaintiff and the defendant and making sure that the jurors have a fair view of the case that they are presented against him. The judge instructs the jury on the law relevant to a case and possible verdicts to the case. A judge pronounces the judgment of the sentence at the end of the trial after the jurors pass the sentence to the judge. The judge interprets the law, determines the meaning of the relevant legal rules. All of these are part of the judge. Now, in the United States, we have, because of federalism, we have a dual court system. We have 50 constitutions, 50 statutory laws, and we have one federal United States Constitution, and we have one federal statutory law passed by the Congress of the United States. And you can see on both systems who presides on the top, the Supreme Court of the United States. Supreme Court of the United States is very important because the Supreme Court of the United States, first, when it comes to the federal government, Supreme Court of the United States interprets the law, and in terms of the states, the Supreme Court of the United States makes sure that the laws that are applied in the constitutions of that does not run against or contrary to what's in the Constitution of the United States. So no state shall, because of the 14th Amendment, for example, as we're going to see in the chapter of civil liberties or the chapter of civil rights, 14th Amendment says that the equal protection of the law, due process of the law, they are guaranteed to the citizens of the United States. And therefore, when states pass laws that violate the citizens of the United States equal protection of the law when it comes to equality or due process of the law, civil liberties, the Supreme Court will pull that case as a violation of the Supreme Court and may nullify the Supreme Court at the state level if the Supreme Court of the United States deemed that it's run contrary to the Constitution of the United States. Supreme Court of the United States has another important power, which is not enshrined in the Constitution of the United States. Supreme Court of the United States can nullify statutes that are passed by the Congress of the United States if they run contrary to the Constitution of the United States. Let's look at, and this is the statute, this practice is better known as judicial review, which is judicial review is the process under which the executive or legislative actions are subject to review by the judiciary. And it's not in Article 3 of the Constitution of the United States. This power is not given to the Constitution, but because of the common law practices in the United States and constitutional law, we still respect precedents in the past. So when, in the case of Marbury versus Madison, for the first time, Chief Justice Marshall, who wrote the opinion of the case of Marbury versus Madison, and who gave the power of judicial review to the Supreme Court of the United States, he wrote that in the case of Marbury versus Madison, and he gave the power of judicial review in that case. And ever since 1803, when he wrote this opinion, that practice had been respected because of the common law, which is a law that respects precedent. He set precedent with this case, which actually put the Supreme Court of the United States as the referee, as the person, as the legal branch of government that interpret the meaning of the Constitution of the United States, which is not in Article 3, as the following video explains.
It goes back to the election of 1800 when Thomas Jefferson, the Democrat-Republicans, beat the Federalists of John Adams. And it's full of politics because Adams, on the last time he was in office, appointed these judges. And when Jefferson came in, he decided he didn't want those judges.
Back then, the inauguration, the change of administration, it didn't really happen until March. So you had this period where Congress was in session, but the president really hadn't changed.
In that 2 or 3 months, the Federalists and President Adams, who had just lost, they realized they're about to become the minority party for the first time ever. And both the executive and the legislative branches going to be dominated by their opponents.
So John Adams and his Federalist colleagues are trying to do whatever they can to stay in power. So one of the plans that they devised is to expand the number of judgeships in the federal judiciary.
Adams's thought in all this was, on the way out, I'm going to appoint a whole bunch of judges and they're going to carry on my legacy.
They passed a law that is nicknamed the Midnight Judges Act.
John Adams is literally signing judicial commissions,
nominating people, getting them confirmed by the Senate
into the waning hours of his presidency before Jefferson takes office.
And what's interesting about this is that John Marshall, who ultimately becomes Chief Justice of the Supreme Court as a part of this whole process. Previously, he is Secretary of State, and he's the one that physically has to deliver the commission to all of these new judges. But they ran out of time.
Whenever Thomas Jefferson comes into office, he realizes that there's all these undelivered judicial commissions for Federalist judges.
There's a stack of commissions on the desk, and Jefferson says, we don't want Federalists as judges.
And he orders his Secretary of State, James Madison, to not deliver them.
It's really a political decision that Jefferson resented the Federalists. He thought there were too many Federalists in the judiciary, and so he wouldn't deliver these appointments.
Well, one of these judges was Marbury.
It just so happened that Marbury had a friend who was the former Attorney General for the United States. And his friend said, well, there was a statute passed several years prior that allowed the Supreme Court the authority to issue something called a writ of mandamus.
A writ of mandamus. It's basically a mandate. So Congress said, if need be, Supreme Court, you can mandate that something happen. So Marbury says, I know. I'll ask the Supreme Court for a writ of mandamus to give me the commission as a federal judge.
Now, there's a lot of irony in this because John Marshall, who was the Supreme Court Chief Justice, was also in charge of delivering the appointments.
John Marshall, who had wanted to deliver the commission to Marbury in the first place and just ran out of time.
So John Marshall gets this request. He's like, ooh, I really want Marbury to get this commission. He's a Federalist. On the other hand, I have this new administration full of anti-Federalists, and I don't want to piss them off.
And as evidence for that belief, the Congress of the United States actually suspends the Supreme Court for a full year.
This was a signal to John Marshall and the other justices on the bench that if you decide this case in the wrong way against the Democratic Republicans, against the Jefferson administration, there are going to be dire consequences.
So John Marshall is faced with a dilemma.
If Marshall rules that Jefferson has to turn over the commissions, he's going to ignore the court order. Imagine that for a second. A president of the United States, Secretary of State, ignoring an order from the United States Supreme Court. What precedent would that set? It would make the Supreme Court an inferior branch of the federal government.
And what's remarkable about this case is the way John Marshall sort of navigates this decision.
In Chief Justice John Marshall's opinion, he essentially poses three different questions. First, he wants to know whether or not there's some sort of legal harm suffered by William Marbury.
He says fundamentally that what the president did was illegal. By refusing to deliver the commission, President Jefferson did not faithfully execute the law.
Next, he wants to know whether there's a remedy at law for those legal injuries.
And Marshall says because Marbury didn't receive that commission, he has a right to sue. And so here we are now 2/3 of the way through the opinion, and it looks like Marbury's about to win.
Then we get to that third question. Can the Supreme Court do anything about it?
And Marshall turns around and basically does a 180-degree turn and says, but we have a problem.
He decides to go back to the Judiciary Act of 1789. And he finds that this writ of mandamus was an expansion of original jurisdiction. It expanded the power that the court has under the Constitution.
What would happen if we could add to the court's original jurisdiction outlined in the Constitution just by passing legislation? Well, that means that you could amend the Constitution with any old act of legislation. Why not amend Article 1, the powers of Congress? Why not amend Article 2, powers of the presidency?
So what does Marshall do? He says, you know what? I don't think that part of the Judiciary Act of 1789 is constitutional.
Chief Justice John Marshall reasons that the Judiciary Act of 1789 essentially amends the Constitution.
The Supreme Court doesn't have the power to issue a mandate that something happened.
Therefore, the part of the Judiciary Act of 1789, that's Section 13, that adds to the Supreme Court's original jurisdiction must be null and void. It cannot stand because it directly conflicts with Article 3, Section 2 of the United States Constitution.
And as a result, he declared a law of Congress unconstitutional.
And from then on, established the precedent for judicial review.
Judicial review.
Judicial review.
Which is the court's greatest power, that only the Supreme Court can say what the Constitution is.
This ability to examine laws, compare them to the Constitution, and when there's a discrepancy, to actually declare that law or part of that law null and void.
It is a seminal case that defines the power of the United States Supreme Court. The Supreme Court today has the power to interpret the Constitution and say what the law is solely because of Marbury versus Madison.
Now, this power of judicial review goes over the two branches of government and makes the Supreme Court of the United States at the apex of the dual system of the court that we have, the state and the federal. The United States has a federal court system and 50 court system. This is the dual system that you're looking at. And now we're talking about jurisdiction. Since you have dual system, so what is the jurisdiction of the state courts and what are the jurisdiction of federal courts? But what is that jurisdiction? A jurisdiction is a court legal authority rooted in the Constitution or a statute by law to hear a particular kind of case. So let's say, for example, a case that deals with homicide in the state of New York. As the federal court has a say on the homicide that took place in New York City, for example. No, that's a statute law. That's unless there's a procedure in the law itself that violates the Constitution of the United States, that violates the due process of the law of the defendant, that case goes into the federal courts. But let's say, for example, somebody commits a crime, kills a person in the state of New York, puts a person in the back of the car, and drives to the state of New Jersey. Now, because of the crime action of crossing state line, that state has that crime has two jurisdictions. It has to be legally prosecuted at the state level and at the federal level. State courts' jurisdiction is broad. The federal court's jurisdiction is narrow. So most of the cases, most of the statutes that are passed by the states are the statutes that regulate our life. So most likely because of the immediacy of the statutes that are passed by the state laws, by state legislators, become a law. And if you think of it, your education, morality, safety, and so on and so forth are all jurisdiction of the state and not the federal government. So these cases are to be tried in the state level. Now, only when there is a federal issue as a interstate, crossing state lines, violation of due process of the law, violation of equal protection, all of this brings that state case to the federal level. Jurisdiction for the federal courts system is based on the subject matter when cases involve. When cases involve the violation of the Constitution of the United States, Bill of Rights, civil liberties, civil rights, equal protection of the law, due process of the law, federal laws, or treaties. There's a federal law that is subject here that a person had violated, or a treaty that is committed that are signed by the United States. So a federal law, let's say, for example, cannabis is, as of today, is legal in the state of Colorado. Now, because of legal state of Colorado, the purchase of cannabis in any part of the state of Colorado is legal. Crossing state line is actually a violation of federal law, because it's the federal law that regulate with cannabis. The crossing state laws with cannabis violates federal law, because federal law regulates the interstate, the borderlines between the states. So once the person took that cannabis from the state and crossed to another state with that cannabis, that became a federal law, and that's it. Maritime action, for example, crimes that took place on a cruise ship or a ship in the sea, the American ship in the sea, as a subject of it. Jurisdiction for federal court system is based on the nature of the parties who are involved in the case. So when we're talking about ambassadors and other public ministers and councils, these are all federal officials, and cases that involve them involve federal courts of the United States. The United States as one of the parties, if the United States is one of these parties in question, a person who is suing the government of the United States, you cannot sue the government of the United States for damages in a state court. You have to go to a federal court. If two states are suing each other, if they have a dispute, say, for example, the famous dispute over the Colorado River. Now, if the two states are disputing an issue, it cannot be judged in the third state or one of those two states. It has to go to the federal government. Disputes between citizens of different states. Okay. Citizen A lives in the state of California, citizen B lives in the state of Oregon, and therefore, if they want to go to court or suing each other, they go to federal courts. They don't go to each other's courts. A court's jurisdiction may be original or appellate. Original jurisdiction is the authority of a court to determine the facts of a case and the applicable law to that case. Okay, so that's original. Well, so the first original jurisdiction, that means that the first person that is responsible for to see, or the court that is responsible to see over, to look over this case. That's what is called original jurisdiction. Appellate jurisdiction is the second step. It's the authority of the court to review on appeal or appeal the decisions of lower courts and determine whether the law is applied correctly or not. Now, the appellate jurisdiction, which is, you cannot appeal a case before a case is originally decided in an original jurisdiction court. So if the person finds that their due process of the law has been violated at the first level when they are in court, they can appeal that violation. They say, look, my due process of the law was violated, and therefore I'm going to go to the appeal. So appellate level is always second at the level that the person appeals to after the first level decides the case. And appellate jurisdiction is not going to look after the facts of the case. They're going to look at the procedure. If your procedures, did you cross-examine? Were you given a chance to cross-examine the evidence brought against your defendant? Were you given, was the lawyer of the defendant given all the information possible from the plaintiff who brought the charges? Was the judge decisions or the process of information was shared with both parties in the case? All of these issues are very important, but they are process. They are not facts. Appellate jurisdiction don't look at facts. The Supreme Court has mostly appellate jurisdiction and limited original jurisdiction. So it has both. The federal courts. So if you look at from the structure, the pyramid that we have, on the top we have one Supreme Court populated by 9 judges. And then you have United States Courts of Appeals. And then we have United States District Courts, 13 Circuit Courts, 94 District Courts. Constitutional Court, a court authorized, we're talking about Constitutional Court, is a court authorized and created under the provision of Article 3, Section 1 of the Constitution. The principal courts are, so Article 3 of the Constitution of the United States created a Supreme Court. And all the courts are who are created under the Supreme Court, they are created after the Constitution was drafted and the Constitution was ratified. The Supreme Court of the United States is the only court that is actually mentioned in the Constitution of the United States in Article 3, Section 1. Who created the courts under the Supreme Court? It's the Congress of the United States. That's a part of the check that the Congress, the legislative branch, has over the judicial branch. Legislative court, a court created by Congress under the power of Article 1, Section 8, to constitute a tribunal inferior to the Supreme Court. This is the actual wording that is in the Constitution of the United States. To constitute tribunal inferior to the Supreme Court of the United States, verbatim. The principal courts in this category are United States Court of Military Appeals, U.S. Tax Court, U.S. Court of Veterans Appeal, the Court of Claims, Federal Courts of the United States Territories. So that's a system. Then you have a federal system and you have a state system. Presides over those is the Supreme Court of the United States. And this is the map of the district courts of the United States. There are 89 district courts in the United States, 89 of them, as you can see below, which are trial courts for civil and criminal cases take place. In addition, there is one each in Washington, D.C., Puerto Rico, and the United States territory, one in each. And this is the map of the district court. So what are you looking at here? And it depends on population. United States Court of Appeals. There are 13 courts of appeals, which primarily hear cases appealed from district courts. 11 are regionally based. The regions are known as circuits. So, circuits. Those are courts of appeals. Now, under these circuits, there are 89 district courts. 11 are regionally, okay. One is located in Washington, D.C., and here's appeals from federal agencies. One court of appeals for federal circuits, which hears cases involving patent and tariffs violations. Okay, now we're moving to the subject of the Supreme Court of the United States. Supreme Court is the only court created directly by the Constitution of the United States, as I have mentioned already. The court is in session from October until June or July. Case starts first by oral arguments. Each case usually receives an hour, which restrict enforcement of time limits. The justice often interpret the questions and interrupt and to question the attorney. Okay, so when a case is brought in front of the Supreme Court of the United States, the lawyer, the plaintiff, and the defendant appear in front of the Supreme Court of the United States, the 9 judges. Each case usually receives an hour. They explain and give the brief to the Supreme Court of the United States, and they are strict in restriction because of the number of the cases they have on the time limit. Then, while the brief is taking place, justice may interpret the attorneys while they are presenting their case. Then, after they listen to that, they have something called conferences. The justices debate the case when they meet on Friday among themselves in seclusion, and there are no records to be taken of that meeting. And then it comes the opinion after they hear the case. There's the majority opinion. We have 9 judges. Let's say, for example, the majority is 5. So the majority opinion the 5 is going to choose a person, usually Chief Justice of the United States choose that person. He's among the majority, and he will ask that judge, the associate judge, to write the opinion, or he will, if he's among the majority, he will write the opinion himself if he chooses so. An opinion of a court that has the support of the majority of members of the court is called majority opinion. Concurring opinion is a written opinion of a judge who agrees with the majority, but feels that the majority opinion does not adequately express his or her own legal reason. That means that I may agree with you, I concur with you, but I have different reasons why I'm concurring you. Not because of what you think the case, but because of different motivations that I have that I'm going to explain in my concurring opinion. And finally, those in the minority, they're going to write, one of them is going to write the dissenting opinion, and is going to express why the minority judges have associate judges, or if the Chief Justice among them, are going to write the opinion written by a judge to record the disagreement with the majority decisions and to express reasons for voting against it. Now, somebody would say, now why would they write a majority? Remember, all of these cases set a precedent, the common law again. They set precedent, and the opinions of the dissenting judges, or the opinion of concurring judges, or the opinion of majority judges, the opinion of the majority, it could be standing for a legal case in the future that has nothing to do with the case in question, but there are similar standings that are important for the case in the future that could be standing for a lawsuit in the future. So lawyers in the United States, they have to memorize cases, the name of the cases, the facts of the cases, the majority opinion, constitutional law, concurrent opinion, dissenting opinion. All of these are very important, and this is where the research part comes in when there are cases are tried in front of the Supreme Court of the United States, that you have to bring the research with you by researching past opinions on a case that has similar facts, or you have a standing that you're interested in that is important in your case. And with that said, this is the end of the chapter. If you have any question, don't hesitate to send me an email. Otherwise, I will see you in the next chapter.